Got some big news here when it comes to defending the Second Amendment rights of state residents against overreaching anti-gun feds. And today, the state of Missouri has asked the United States Supreme Court to allow enforcement of a state law that would ban police officers from enforcing federal gun control laws, the Second Amendment Preservation Act. A lot of eyes across the country are on this particular case, and there's a big reason for it. Before I jump into it, I want to thank the sponsor of the video, and that's TriStar Trading. Guys, fall is upon us. They have restocked the Wubbies, they have Black Multicam, they have Woodland, and the new Vietnam Tiger Stripe. I love it. Small, thin, extremely warm, pack it up, throw it in a bag, throw it in the trunk of the car. Extremely warm. And they have re-upped Smokey the Bear, Only You Can Prevent Tyranny shirts, and the official member of a government watch list shirts. Shirts up to 6XL. They have hooded sweatshirts as well, all in stock as of today. They will not last long. Jump on it. Links are down below. Thanks to TriStar Trading for being a phenomenal friend and sponsor of this channel, and a friend to my family and children. It means more than you know. Guys, my name is Jared. This is Guns and Gadgets, and on this channel I bring you Second Amendment news every single day, no matter where it happens in this country, from litigation to legislation and everything in between. And this case is a big one. You want to stay in the know? Subscribe to the channel down below, share the video, like the video, turn the bell notifications on to all notifications. Takes you about 8 seconds of your life, and you'll stay in the know with everything going on across the country. So why are so many people watching this case? What's so big about it? Well, Joe Biden had his Attorney General, Merrick Garland, and the Department of Justice sue the state of Missouri because they passed a law prohibiting state officials from assisting the feds in violating the Second Amendment rights of Missouri citizens. The emergency application that they sent to the Supreme Court asks the Supreme Court justices to block a lower court ruling finding the state's law unconstitutional. Now, Missouri claims that state lawmakers enacted the Second Amendment Preservation Act in response to the Supreme Court justices' own Second Amendment rulings. Missouri thinks that the Supreme Court rulings make some federal gun laws unconstitutional. Yes, every gun control law is unconstitutional. So, Missouri's state legislature passed the Second Amendment Preservation Act, barring enforcement within the borders of Missouri. Sounds like a no-brainer. In fact, every state should have this. Let's look at this emergency application together. We'll just take a peek at a little bit of it, because I think it's very important that you all understand what the state is saying to stop the government from overturning this law. Here is the case on the screen, and it is the state of Missouri et al. Versus the United States of America. And this application was submitted to Brett Kavanaugh, who is responsible for the 8th Circuit. This says, like many states, Missouri has disagreements with the federal government about the correct interpretation of the Second Amendment, and thus how to interpret and enforce certain federal firearms statutes. In light of this court's recent Second Amendment decisions, the Missouri General Assembly believes that a small number of federal statutes may be unconstitutional, that the doctrine in this area is changing, and that Missouri officials ought to strive to comply with the Second Amendment to the maximum extent possible. So, in 2021, Missouri passed a law, the Second Amendment Preservation Act, publicly stating the legislature's interpretation of the Second Amendment, prohibiting Missouri's local governments from helping federal officials to enforce federal laws not in line with that interpretation, and creating a remedy akin to Section 1983 against Missouri officials for violations of the Second Amendment. And that's a civil right violation. In response, the United States sued Missouri. The United States does not dispute and has in fact conceded that Missouri has a right under the 10th Amendment not to lend its resources to assist federal enforcement. So the United States instead sued under a novel theory that a state cannot exercise its 10th Amendment authority if the state's factual reason for doing so is mistaken. Here, the United States asserts in its complaint that the statute should be declared unconstitutional because Missouri's reason for prohibiting local governments from facilitating federal enforcement is premised on an incorrect interpretation of the Second Amendment. The district court accepted this novel theory. At the federal government's invitation, the district court focused not on what the law does, but on the legislature's reason for passing it, fixating on the statute's legislative findings, which are, of course, purely declaratory. The district court concluded that the Missouri General Assembly's statement interpreting the Second Amendment is itself unconstitutional. And because the General Assembly's interpretation was central to the reason the legislature directed state agencies not to assist with federal enforcement, the district court struck down the act in its entirety. Aggravating that error, the district court did so even though no named defendant is authorized to enforce the law. The district court's order is deeply flawed for two basic reasons. And the first is that judicial orders have to go against the named defendants. And in this case, none of the people named can actually enforce Missouri law. The governor, the AG, etc. They don't go out and patrol the streets. So because of that, this should be dropped immediately. And second, that the U.S. has no standing because the United States isn't injured by Missouri telling their state officials they can't enforce federal law. Good points on this challenge, really good points. Pointing out these and other problems, Missouri asked the district court to stay the order on March 8th of 2023, one day after the district court entered it. The district court declined to enter a full stay, but agreed to stay its order administratively until the Eighth Circuit could rule on a motion for a stay pending appeal. More than 6 months passed without a ruling by the Eighth Circuit, and Missouri's law was allowed to stay in effect. Then, last Friday, on September 29th of 2023, the Eighth Circuit denied Missouri's stay motion in a one-line order. The court offered no analysis. The Eighth Circuit's order is thus similar to the Fifth Circuit's order last year in Net Choice LLC v. Paxton, where the Fifth Circuit issued a one-sentence order on a motion filed 5 months earlier, which deprived applicants of the careful review and a meaningful decision to which they are entitled. This court vacated the Fifth Circuit's order and should do the same here. The district court's order here much more easily justifies a stay. Staying the district court's order would maintain the status quo pending appeal. The Missouri General Assembly passed the Second Amendment Preservation Act in June of 2021. The United States did not sue until February of 2022 and never sought preliminary injunctive relief. So, except for the 24-hour period between when the district court entered its order and its administrative stay, and 2 business days between the Eighth Circuit issuing a one-line order and Missouri filing this application, Missouri's law has been allowed to stay in effect for more than 2 years. By issuing a stay, this court would maintain this status quo. Absent a stay, the state of Missouri and its citizens face immediate irreparable harm. Anytime a state is enjoined by a court from effectuating statutes enacted by representatives of its people, it suffers a form of irreparable injury. And here, where the state has passed a statute to enable its citizens to hold their own state government accountable, the injury is especially poignant. The injunction encroaches on the General Assembly's sovereign ability to define the authority of the state's own subdivisions. It denies everyday Missourians the right to hold their own state government accountable. Let's jump to the conclusion here. When courts declare state laws unconstitutional and enjoin state officials from enforcing them, this court's ordinary practice is to suspend those injunctions from taking effect pending appellate review. There is no reason to depart from this practice here. The district court upended the constitutional balance between the federal government and Missouri on a matter central to Missouri's sovereignty: the conduct of Missouri law enforcement agencies and political subdivisions. Under the district court's order, the General Assembly can no longer set the bounds of Missouri law enforcement. The decision exacts a grave injury because when the federal government asserts authority over a state's most fundamental political processes, it strikes at the heart of the political accountability so essential to our liberty and Republican form of government. This court should immediately grant appellants temporary administrative relief from the district court's permanent injunction pending consideration of this application. And the court should stay the district court's permanent injunction pending both the Eighth Circuit's issuance of a decision on the merits and the opportunity to seek timely review of that decision from this court on a petition for writ of certiorari. So the emergency application, like I said, was submitted to Justice Brett Kavanaugh, who presides over applications from the 8th Circuit. And Justice Kavanaugh can respond to the application himself or send it to the full court for review. So this is something, like I said, a lot of people are watching, a lot of states are watching, because there are a couple states that pass similar laws. However, Missouri's was the biggest and the baddest and had the most teeth. So Joe Biden said, wait a second, you can't stop the ATF from doing ATF things there. And what the state law that was passed actually doesn't stop the ATF from doing things, or FBI or anybody else, but they're not going to help. And when the feds come to do raids or search warrants, they can't do it without the help of local or state law enforcement because they don't have the numbers. There's not a lot of ATF agents. There's not a lot of FBI agents to where they can just send, 40, 50, 60 of them to do a warrant, or 200 of them to do a major bust. They just don't have the numbers. So they depend on state and local law enforcement. And Missouri said if you do it, you're not going to be employable. You're going to lose your job. $50K, you're going to be fined. So great law, the Second Amendment Preservation Act. We'll see what happens. Will the Supreme Court do what they do historically in cases like this, which is to stop the stay, or to stop the injunction, rather? Or do they say, you know what, your law can't be enforced, fight it in the courts? I don't know how this goes. This could go either way, and no matter which way it goes, people are watching. Feds are watching. Patriots are watching. What do you think? Let me know down below. You like the Wubbies? Which one is your favorite of the three? Tiger Stripe, Woodland, Black Multicam? I have all three. I love them. They're so warm. One in the car, one in the truck, one on the motorcycle. Love them. Links down below. Guys and gals, I appreciate y'all more than you know. Thank you for allowing me to do what it is that I love. Can't do it without you. I'll see you all in the next one. Take care.